Now, we'll hear next on specifics regarding arbitration agreements involving Chinese parties, including sino-foreign joint venture companies and wholly foreign-owned companies incorporated in China within the framework of EU-related supply chains. We have three speakers now up. Dr. Guojian, Adolf Peter once more, and Elise Meissner. I've already introduced Adolf to you. To briefly introduce Dr. Xu, he is Distinguished Dean and Professor at the Shanghai University of Political Science and Law, and both a senior partner of the SGLA law firm. He studied law in China, Switzerland, the Netherlands, and Germany, concluding his doctoral studies at the University of Hamburg. And Dr. Xu is also Vice President of the China Society of Private International Law and a panelist of the China International Economic and Trade Arbitration Commission, the Shanghai International Arbitration Center, and the arbitration commissions of a number of Chinese cities. As counsel and arbitrator, he has a rich track record of settling commercial dispute cases, and we're very much looking forward to his insights today. We also have Dr. Elise Meissner, who's been practicing since 2009 and is now the founding partner after various stages in internationally renowned law firms as a partner of Meissner and Passin, Rechtsanwalt GmbH in Vienna, and an independent senior advisor of Nivelian AG. She is dual admitted attorney with the Vienna and Munich Bar Association, a listed arbitrator with various institutions, fellow of the Hong Kong Institute of Arbitrators, and chair of the European Chinese Arbitrators Association. She has a well-established track record in representing multinational clients in international arbitration proceedings and the various rules. And now again, without much further ado, I think, Elise, you will go first. Please, the floor is yours.
Right. Many thanks, Marcus, for the kind introduction, and welcome everyone. I'm honored to be here. Well, many thanks for introducing the topic, and we are, out of time a bit, but I'm trying to be precise. So just to give everyone an overview and give some points of reference, since it's a very specific topic in this broad but very interesting and most hot topic, ESG and climate litigation. I just want to give the audience the points of reference where we stand with the Chinese specifics of this topic. As already Adolf shared in on some slides, I have here also an example of the supply chain, how it could look like. Having said that, it is not as usual, as common as maybe 20 years ago, that the Chinese company is at the end of the supply chain. Maybe Dr. Xu can confirm that as well. So we have probably the Chinese suppliers somewhere in the middle nowadays. We have maybe Sri Lanka and Africa at the end, but this is just an example because, suitable for the topic regarding the enforcement of rights. So that's maybe an example in any event that we have a liability issue with the supplier situated in China, how we're going to enforce the rights and damages caused by that ESG default. As Alice both and Adolf's topic touched upon, we have, of course, the joinder. It's a very specific and very, very important topic for enforcement, since we do not want to have different arbitration awards and have to go through the enforcement in China several times. It's of course useful to have one single award against the party involved in China. Just to my topic, and it's very close to me, Dr. Xu's topic, so I will probably refer to his slides. I won't touch upon those topics so to avoid any overlap. Since we have to, international-wise, every party who's a substantial supply chain contractual party has to conduct its own health check. It is very important, if you do have a Chinese party involved in the supply chain, to check the choice of arbitration institution as well as place of arbitration. It's not only the territorial principle which is relevant in China, so i.e. place of arbitration, but the point of reference is very much also the choice of arbitration institution, what we're going to touch upon later in the slides. So there is the broadest and the most important differentiation under PR Chinese law is when we look at the recognition and enforcement of foreign arbitral or any arbitration arbitral awards is the differentiation between domestic arbitral awards, foreign related award, which is very unique under Chinese law, and the foreign award. The applicable law, and it's of course the arbitration law of PR China, which is in the transit of revision. We hopefully get a new arbitration law soon, but I understood it's still not enforced yet. The civil procedural law and the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention, as we all know. And of course, the guidelines and the interpretation of the SPC are most important, because we'll come to that. So the SPC, the Supreme People's Court, has adopted a lot of interpretations, guideline notices, and also related to civil procedural law, CPL, that should mean. The arbitration law sets out special provisions for arbitration involving foreign elements in Article 65 to Article 73. The definition of foreign element is very controversial, and it's actually more academic discussion, which we will also look into more deeply when Dr. Su's slides. The foreign element, one definition you can find is in Article 304, the opinions of the SPC, civil cases in which one party or both parties are foreigners, stateless persons, foreign enterprises or organizations, and legal factors outrage or termination of the civil legal relationship between the parties concerned take place at abroad, or the subject matter of an action is located at abroad shall be the civil case involving foreign elements. It's a very broad definition, and it's a very problematic definition. But I'll leave this topic to Dr. Su, because he will actually go through some really interesting case law. I'm going to concentrate further down the road regarding enforcement of foreign awards. I think all on the panel and or the audience, the majority of the audience know very well the New York Convention. I don't have to repeat myself, but I would like to highlight certain problematic definitions that are understood differently under PR Chinese procedural law. The Article 1, the convention obviously linked to the territorial principle, meaning that the convention shall apply to the recognition and enforcement of arbitral awards made in a territory of a state other than the state where the recognition and enforcement of such awards are sought, meaning that the place of arbitration is crucial here, and arising out of different persons. And the second sentence, it says that it shall also apply to arbitral awards not considered as domestic awards, which is very good in terms of the differentiation that we touched upon of the PR Chinese procedural code act, meaning that those awards which are not domestic award, we would understand that should automatically fall under New York Convention. That's a prima facie understanding, which is not correct if we look at the PR Chinese law. Article 269 Civil Procedure Code of China says that if an award made by a foreign arbitral organ, which is an institution meaning, requires the recognition and enforcement by a People's Court of PRC China, shall directly apply to the intermediate People's Court at the place where the party subject to enforcement has its domicile, whereas property is located. This definition refers to actually foreign awards, so foreign related awards, those that cannot be deemed as domestic. So meaning that we have now the first differentiation to the New York Convention. It refers not to the place of arbitration, but to the institution which administers administers the arbitration proceeding. And further down, we will also discuss the that the foreign related award does not fall under the application of the New York Convention. Awards rendered by foreign arbitral institutions in PR China are definitely foreign related. Having said that, sorry, I have to go back. The foreign related, this point is quite interesting since it's quite new. Foreign arbitration institutions have only been admitted most recently. So there are certain meeting minutes on a trial of foreign related maritime and commercial cases published by the SPC. So there are, of course, foreign offices of foreign arbitration institutions, but that is actually the recent development. They have not been able to set up their offices or their subcommissions for a very long time in China. Those arbitration institutions or subcommissions of foreign arbitration institution seated in China may now, under certain limitations, administer arbitration proceedings. And those arbitration proceedings, although place of arbitration is China, is deemed as foreign related. So that's major difference than the understanding of the New York Convention. Right, I'm just going to briefly touch upon some loopholes maybe one may see when we enforce a foreign award in China. Article 5, para 2a, New York Convention says recognition enforcement of an arbitral award may also be refused by the competent authority, hence the intermediate People's Court in China, where recognition enforcement is sought, finds out that the subject matter of the difference is not capable of settlement by arbitration under the law of that country. That topics really touch upon the scope of submission to arbitration or the tribunal's authority. Here we come back to the differentiation. So there were some cases that a domestic case cannot be submitted to a foreign arbitration institution. So we do not see that, of course, that the foreign arbitration institution accepts such cases. But if in any event we do have an award, it would actually exceed the scope of submission of arbitration. And there will be actually problems in regards to enforcement under the applicable rules. The second loophole, if I may say, the recognition or enforcement of the award would be contrary to the public policy of that country. That's actually, according to the recent developments, is actually very arbitration friendly. One may think that the Chinese courts would easily accept the excuse of public policy or public interest, which is actually not the case. So the most recent one, the Jacobson case, the Jacobson Golf Course Design Siju Sen Huishuan Property Development 2015, the counterparty rejected or applied for a set aside due to the public policy, due to development plans, and it has been rejected by the intermediate court or the higher People's Court. What is also very arbitration friendly when it comes to enforcement of foreign awards is the newly established or quite newly established prior reporting system, meaning that the intermediate court, actually in first instance, which we will call upon when we would like to have a foreign award recognized and have it enforced, we would call upon the intermediate court, may immediately enforce the award, option 1, or option 2, it may call upon a higher instance, but it may not, option 3, refuse the enforcement of the award or issue a negative decision, meaning that it has to report to the next instance, which would be the High People's Court, and the High People's Court will review it, and probably with the reason why the intermediate court thinks that this award should in particular be refused. the High People's Court may also not make a negative decision. It may make a positive decision in any event if the High People's Court shares the opinion that the recognition and enforcement of such award shall be declined. It is only allowed to report such decision to the Supreme People's Court. So it will end up with the Supreme People's Court as the highest instance to judge upon whether this international or this foreign arbitral award may be refused and may not be recognized. So this system has made it very difficult for the Supreme Court, so for the intermediate courts, for the local courts to decline recognition and to decline enforcement. If we may look at the nature of judges, it may be easier for them to recognize the foreign award, and it's actually very arbitration friendly. So this has led to a fewer cases where the courts actually issue a negative decision. Yep, and with that, I would like to finalize my topic. Thanks, Marcus.
Alice has already talked about the difference between the domestic and foreign-related arbitrations in China. And what I would like to talk are the following 4.5 points, and I would like to address. And the very first point, I would like also to repeat the dual systems and rules for domestic and foreign-related arbitrations in China. The People's Republic of China has a dual systems of arbitration, namely a system of domestic arbitration for domestic disputes and a parallel system of arbitration for foreign-related disputes, namely international disputes. As a civil law country, China currently has two main legislations on arbitration. There are arbitration law of August 31st, 1994, which is quite old, which is under the revision. And the second main legislation on arbitration is the civil procedural law. And this law has been newly amended on January 1st, 2022. Chapter 7 of arbitration law, which consists of 9 articles, is the special regulations for foreign arbitration. Chapter 26 of civil procedural law is also the special regulations for foreign arbitration, namely arbitration on foreign-related disputes. The second point which I would like to address is what is an international arbitration or foreign-related arbitration in China. This point, Alice has already discussed a little bit. So I would like to talk about so-called 5 criterion, how to identify foreign-related arbitration in China. In arbitration over a dispute which has one of the following circumstances may be identified as an international arbitration. First, one of the parties concerned or both parties concerned are foreign citizens, foreign legal persons, or other organizations or stateless persons. It is not that difficult to identify arbitration with foreign persons. In the practice, it's easy to do this. The second is the habitual residence of one of the parties concerned or of both parties concerned is outside the territory of the People's Republic of China. The third point is the subject matter is outside of the territory of the People's Republic of China. For instance, the goods are located outside of China, or instruction site is outside of China. The fourth is the legal fact that causes the civil relation to create, change, or terminate occurs outside the territory of the People's Republic of China. And in particular, in such a case, relates to particularly the torts cases. And then the last one, the fifth point, there is any other circumstance which can be identified as a foreign-related civil relation. So these are, as Alice also pointed out, are the interpretations made by the Supreme People's Court, which in practice, of course, that's not easy to apply. The third issue which I would like to address is the arbitration agreements submitting disputes without foreign-related factors to foreign arbitration institution for arbitration shall be declared null and void. This is very important for lawyers practicing or doing something with China. Only parties of a dispute which has one of the above said circumstances, namely a foreign-related dispute, may agree to submit their dispute to arbitration abroad. Otherwise, the arbitration agreements shall be declared null and void. Any arbitral award made abroad based on such arbitration agreements will not be recognized and enforced by Chinese courts in China. The Supreme People's Court expressed its opinion in its reply to Beijing High Court in the year of 2013, which denied recognition and enforcement of an arbitral award made by Korean Commercial Arbitration Court. In this case, parties were two enterprises incorporated in China who agreed in an arbitration agreement to submit their disputes for arbitration to Korean Commercial Arbitration Court. The Supreme People's Court of China thought that such arbitration agreements lacking foreign elements shall be declared null and void. Therefore, the arbitral award made by foreign arbitration court, namely Korean Commercial Arbitration Court in this case, shall not be recognized and enforced in China. The next issue which I would like to discuss is the new trends in China to soften thresholds of foreign-related disputes. A famous case showing such trend in China is the case of recognition and enforcement of an arbitral award given by SIAC, Singapore International Arbitration Center, in the case of a dispute between two Chinese enterprises, namely Siemens International Trade Shanghai Corporation Limited and Shanghai Golden Landmark Corporation Limited. On November 27, 2015, the Shanghai First Intermediate People's Court made a ruling to recognize the above said arbitral award rendered by SIAC. The arbitral award was based on the arbitration agreement concluded by parties and by two Chinese enterprises. which were incorporated in Shanghai Pilot Free Trade Zone. And the court thought that the parties who incorporated in the Pilot Free Trade Zone shall be deemed similar to foreign parties. So this is one reason why the court recognized the arbitration award given by the SIAC. And the second ground the court made this ruling is that the performance of the contract has foreign-related characteristics. The goods and the contract have been first transported from abroad to the bonded area. And after the customs declaration, and the goods have been transported from the bonded area to outside. And such a transaction, that according to the opinion of the court, is similar to an international trade transaction. And the very last reason why the court make such a ruling is that the golden landmark, which has been requested to implement the arbitral award, was the applicant in the arbitration case. And this means this company did recognize the validity of the arbitration agreement. And but in the face of the recognition and the enforcement, and it denied the validity of the arbitration agreement. And in accordance with the opinion of the court, this is against the principle of estoppel. And so the last issue which I would like to talk is the point which Alice has also briefly addressed. That's the arbitral awards made by a foreign arbitration institution in China. And foreign arbitral award, whether that's an arbitral award made by a foreign arbitration institution in China, whether it is an international arbitral award or a domestic arbitral award. And to this issue, and there are a couple of cases according to which the Chinese courts do believe and think such arbitral awards are the domestic awards, and which subject to the provisions of the judiciary review. So these are the 5 points which I would like to share with the audience.
Yeah, adapting model clauses. I mean, when we talk about arbitration in relation to China, China has brilliant, excellent arbitration institutions. And each of the arbitration institutions has model clauses. Yeah? And the main question is, can you just take these model clauses, in particular, if you're a foreign company, non-Chinese company, European company, American company, I would recommend not just to take a model clause. Yeah, you should really adapt the model clauses. And I just want to focus on 2 model clauses. One is the CTAC. Of course, CTAC is the most known Chinese arbitration institution nowadays, and another one is SHIAC. It's one of the most important arbitration institutions in Shanghai, the Shanghai International Arbitration Center. So what you typically have, a model clause refers, of course, to the arbitration institution, to the applicable arbitration rules. The seat of arbitration is very relevant for the applicable procedural arbitration law for setting aside proceedings and so on. Then the venue, where the hearing is held, and also the language of arbitration. When we take a look at the SHIAC model clause, then we don't even have that. We only have here a reference to the seat of arbitration in China, and which arbitration rules are applicable, and of course the arbitration institution. So we need to work a little bit on that. And I prepared here some hints, some practical tips. If you conclude an arbitration agreement in relation to China, I would always, and that's the first tip here, I would always talk about, or basically install in the agreement the number of arbitrators. It's either a sole arbitrator or tribunal of 3 arbitrators, because you need to understand one thing. If you want to have 1 arbitrator, the default rule in those institutions is 3 arbitrators. So if it's not such a complex case, if it's a more small case, then you may want to go for 1 sole arbitrator. But you need to expressly mention that. You need to agree upon that in the arbitration agreement. Presiding arbitrator, nationality is another thing. If you want to avoid that the presiding arbitrator is Chinese, for example, if you're having a dispute against a Chinese company, then you should say so. You can express that by stipulating that the nationality of the presiding arbitrator must be neutral, must be that the presiding arbitrator does not have the nationality of any of the parties involved. This is very easy, but you need to think about that. You need to agree upon that, clearly, expressly mention it in the arbitration agreement. Language of arbitration is another important issue. If you don't say nothing in the arbitration agreement, it could be the default rule is Chinese. You can see that here in SHIAC arbitration rules, in CEDAC arbitration rules, the default rule leads to Chinese. So if you want to avoid that the arbitration proceedings are in Chinese language, then please go ahead, agree upon the language of arbitration. This is also quite important for foreign companies. Then, of course, it's also very, very important to agree upon evidence and document production related issues. And I would always recommend to my clients to actually agree upon the IBA evidence rules, or there's also very, very good rules, guidance from the CEDAC. The CEDAC, this is not the CEDAC arbitration rules, but it's actually, you can see here the CEDAC guidelines on evidence. And the big difference is if you agree upon a set of arbitration rules, for example, the CEDAC arbitration rules, you do not automatically agree upon the CEDAC guidelines on evidence. You need to clearly say that in the arbitration agreement. And they're quite similar. I would say they're based on those IBA rules on the taking of evidence. The IBA rules, I would say, are the most detailed ones. It allows you to have cross-examinations. You have a very, very detailed document production procedure. As you can see, I don't have the time to go through this, but I would definitely recommend to everyone to really consider this. because there is no guarantee in an arbitration seated in China that you, if you want to have a document production procedure, that you get one if you don't agree upon this, upon these guidelines. Yeah, because in arbitration, in the arbitration rules of arbitration institutions, you usually do not have this kind of detailed evidence rules, and also in the laws, in the applicable arbitration laws, in the lex arbitri, yeah, because I talked about the seat of arbitration. Yeah, you don't have this detailed evidence rules in the laws, so that's why we need to agree upon those additional soft law guidelines, and we can make it mandatory if the parties agree upon that in the arbitration agreements. Then the arbitral tribunal has to mandatorily apply that. Usually in international arbitration, even if parties do not agree upon it, most arbitral tribunals, and I'm talking about international arbitrations, will use the IBA rules on the taking of evidence as a guidance. But this cannot be guaranteed if you're dealing with the Chinese arbitral tribunal, and maybe you don't want to have such a strong common law aspect. Yeah, maybe you're leaning more towards civil law. You don't like cross examinations and these kind of things. You want to limit the document production. You also can agree upon the Prague rules. So this is yet another soft law document or guidance in relation to evidence procedure that you can agree upon in the arbitration agreement, and you should definitely do that. So that's my recommendation. And last but not least, because I know that the time is very, very limited. Yeah, also please agree upon the law of the arbitration agreement. Many don't know that, yeah, and most of the arbitration agreements, they don't contain that. Yeah, there are several applicable laws that you need to consider, and one of it is the law of the arbitration agreement. And this is very, very important for validity questions. Yeah, is an arbitration agreement valid? How to interpret the scope of an arbitration agreement, and these kind of questions can be very, very relevant, and you really don't want to have a long dispute over what is the law of the arbitration agreement. Maybe you get some bad surprises. So this is also very, very crucial. I recommend that the seat of the arbitration, the applicable arbitration law, should actually be the same as the law of the arbitration agreement. Yeah, makes things more and more easy. And I talked before about this consolidations and jointers clause. Yeah, in relation to China, you need to be very careful with that. What I said before is it's for consolidations very helpful if we have along the entire supply chain identical arbitration clauses. This makes it much easier to have a consolidation. But what we heard before is the foreign related contract issue. And in particular, in terms of consolidations, you have to be very, very careful. Because, for example, what happens if, I give you this example here, if supply chain leading in the main contract, between two European parties, there is an ICC arbitration clause in Paris. So foreign arbitration, non-Chinese arbitration institution, and the foreign and non-Chinese arbitration seat. So then this will be passed on. These obligations, everyone will have the same, by contractual cascading, everyone will have the same arbitration clause. But then we come to Chinese entities. And for example, we may have subcontractors, agreements between subcontractors, lower tier subcontractors, sub-suppliers that are both Chinese entities, and where this contract is not a foreign related contract. So if we have a contract that is not foreign related, and we have ICC Paris, then we have an issue, because that could lead to an invalid arbitration clause in terms of this one contract between the two Chinese entities. And when I'm talking about Chinese entities, then I'm also talking about sino-foreign joint ventures, because they are registered, incorporated in China. It could also even be wholly foreign-owned entities. The only exception is a contract between two wholly foreign-owned entities. If they're seated, registered in a pilot free trade zone in China, then it's automatically considered foreign-related. But you need to be very, very careful and consider that as well, and have some exceptions for these kind of situations. But I'm looking at the time now. The time is up, and I want to actually go to my next. And you can of course contact me if you want to have more details. I wrote a lot of articles, intensive articles in all kinds of international journals about these issues. So please do not hesitate to contact me.